Where it comes to the Trump administration, everywhere I go, people keep asking me, can they do that? I'm MSNBC legal correspondent Lisa Rubin, and welcome to the next installment of Can They Do That? I'm here today with my guest, New Jersey Attorney General Matt Platkin. Matt has served as New Jersey's AG, first in an acting capacity, then in a permanent capacity since 2022, when he was first named to the role by Governor Phil Murphy. Matt has criminal law authority, which differentiates him from a lot of other states' attorneys general. And he has drawn a lot of attention as of late for his strategic leadership of a number of initiatives that states' attorneys general have done together with respect to Trump administration policies that impact his state's residents and the bottom lines for their state. Welcome to Can They Do That?
Thanks so much for having me, Lisa.
I'm very happy to do it. So before we get into the specifics of can they do that and why New Jersey is demanding in courts that question, can you just describe in basic terms, what do you do as the Attorney General of New Jersey, and what's the mission of your office as you see it?
I think what I do and the mission are sort of one and the same. We keep the residents of my state safe, and we keep them safe. You mentioned my criminal authority. New Jersey is somewhat unique in how broad the criminal authority is for the Attorney General, and there's a uniquely New Jersey history that accounts for that.
And I should mention, like lots of other states' attorneys general have very limited criminal authority, if that, including here in New York, where I live. Tish James doesn't have much criminal law authority, much to the consternation sometimes of residents of the state.
So I have broad criminal authority. We don't have elected prosecutors in New Jersey. All of the prosecutors in the state report up to me. All law enforcement, all 42,000 cops report up to me. We keep them safe from violent crime. We keep them safe from companies that want to rip them off, so social media companies that have targeted kids. We keep them safe from opioid companies. We keep them safe from civil rights violations. Broadly speaking, we keep the 9.5 million residents of my state safe.
But like all of the county prosecutors, the DAs, none of them are elected, all of them are appointed, and all of them report to you.
Correct.
That makes you fairly unique, I would guess, among states' attorneys general?
Very. Some AGs are the only DA in their state, so like Delaware, for instance. But yeah, in terms of the AG having no elected attorneys or prosecutors in their state and complete authority over the criminal justice system is fairly unique. And there is a history as to why that's the case in New Jersey.
That sounds like another episode of Can They Do That, focused on why New Jersey did that. We're now 60 plus days into Trump 2.0.
Can't believe that's all it is.
I can't either. Your office is right in the thick of so many of the battles against executive orders and other policy changes where the lawfulness or sometimes even the very constitutionality of what's being done is being challenged in court. Do you feel it's a fair characterization to say that, putting aside a couple of impact litigation groups and unions, states are really the driver of the litigation right now that's making a difference?
I think we've been a significant driver of it, sure. And I think that's because, like I said before, states' attorneys general are responsible, whether they have criminal authority or not. They're responsible for protecting their residents from harm. And I love the title of your show, because the answer the courts have given to this administration, at least for cases New Jersey's been in, has been uniformly no. They cannot do what they have done because they have routinely violated the law, routinely hurt our residents. And for me, and I think I speak for all of my colleagues that have joined or led these cases, we think about two questions.
Okay.
Is anyone, including a federal administration, violating the law? And are they hurting the residents of our state? If those answers are yes, then it's not just like a choice I have an obligation to stand up for them and protect them.
I don't have a memory. Granted, I wasn't in this job at the time. I was a civilian, I was a lawyer, but I don't have a firm memory of states being the principal driver of the pushback against Trump 1.0. What do you think accounts for that differentiation? And why is it that maybe states feel like they're playing such a more prominent role? Like when I think about it, one of the reasons that stands out to me is in Trump 1.0, you had a civil resistance. We could see protests in the streets, the Women's March maybe being the best physical manifestation of that. But we're really not seeing a lot of that now. The pushback right now seems to be principally a litigation-oriented pushback. What do you think accounts for the fact that states seem so much more prominent right now in that, I'll call it the pushback, like not the resistance, right? The resistance is Trump 1.0. But now we're like in this place where pushback, and particularly litigation pushback, matters quite a bit with states at the head, if not co-sharing the head of the table with some other folks.
Look, you said it. I don't view us as the legal resistance or the legal pushback. And frankly, I think one difference between now and 4 years ago is myself and none of my colleagues have questioned whether this president was duly elected, whether he has a legitimate presidency, which many Republican attorneys general challenged in 2020. But what he can't do is violate the law and hurt people in our states. And so in the first term, there was a fair amount of lawsuits. In fact, well over 100 lawsuits filed by state attorneys general against the administration. They were successful over 80% of the time. Now, that's historically unprecedented. Typically, it's about 20% of state attorneys general lawsuits against the federal administration are successful. Successful 80% of the time. This time around, we've been successful 100% through the first 60 days. That's because the first Trump administration...
I want to stop there for a second because I'd be irresponsible if I didn't. There is literally not a single suit brought by states' attorneys general where even the emergency relief you've requested has not been granted?
In the cases that New Jersey's been a part of, no. And we've gotten either a TRO, a temporary restraining order, meaning immediate relief, or an injunction in every case that we have sought it, with the exception of one case that just hasn't been decided yet. But I'm confident we have brought it's because we brought every case based on those two questions that I said. And this administration, in the first Trump administration, and now again we're seeing it in the first 60 plus days of this administration, they violate the law in such a brazen way. These aren't close calls in many of these cases. These are clear violations of the law and clear harms to our states and our residents. And that's why you've seen courts across the ideological spectrum, by the way, step in.
That's fair. I think that's incredibly fair. And by the way, not just courts across the ideological spectrum, but I was really struck the other day. I was looking online, and in one of my Twitter feeds, there was somebody giving a very full-throated defense of Judge Boasberg. And granted, that's not a case in which New Jersey is involved, but the defense of Judge Boasberg was coming from Ed Whelan, who is a leading conservative legal thinker. I think it's really interesting to see that not only are the judges who are finding what they're doing unlawful from, in some respects, conservative legal movement raised people, but the civilians who are saying this is actually totally lawful and your criticism of this person is bordering on the lawless are also starting to come from those flanks as well.
It's funny. I saw a conservative commentator tweet that there's a judicial coup going on. Like, yeah, that's what the rule of law is. We adhere to what judges say. And if you don't like it, you can appeal it. You don't get to say that the judge is illegitimate, that their decision shouldn't be followed, that they should be impeached, that they should be physically threatened. We've seen unprecedented amount of threats of physical violence. And in New Jersey, we've experienced that in real life.
No, I realize that. I mean, Judge Salas has been a guest on Nicole Wallace's show multiple times talking about the tragedy that her family has endured. In New Jersey, you take that, I would imagine, more seriously than many because you know what happens when a threat crosses the line into actual violence.
No question.
One of the things you were describing like your thought process of what are the two questions I ask myself when I get New Jersey involved in a lawsuit. The state of New Jersey, it's not, I'm going to push back on you for a second. The state of New Jersey is not the ACLU funded by donors or members. It's not a taxpayer financed, it is a taxpayer financed law firm. It's not a law firm that makes, decisions at its whims about how to use its resources for good. Is there a cost-benefit analysis that's going through your head at any point in time about, look, my office is maybe resource-rich, but it is also, in some respects, resource-constrained. When do I make the determination that this lawsuit is worth New Jersey joining or New Jersey leading?
Yeah, absolutely. And I think that's true in any case, but it's particularly true when you're talking about the pace and the volume of cases that we're seeing involving this administration. So again, those two questions guide me, because if I can say the law is clearly being broken and residents are clearly being harmed, take the funding freeze case.
Okay.
People calling my office saying, I have a doctor's appointment and I don't know if my Medicaid card is going to be accepted while our state Medicaid system was frozen. A notice that came to my office to freeze the drug cartel task force that we are part of that prosecutes drug trafficking. Head Start. People didn't know if they could take their kids to early childhood programs that day. Clear harms to our residents, clear need to step in and provide immediate relief, which we did and got those funds
And
flowing
are
again.
you getting that immediate relief? Because, my law school classmate and friend Steve Vladeck wrote a really great piece in the Times called The Tom and Daisy Presidency. And the minute I saw the headline, I knew exactly what he was talking about. He was talking about the fact that these folks are going to break things. And while courts are going to provide some corrective measures, they're never going to be fully whole again. In some respects, the damage that they create in the interim before the litigation-related relief comes into play will be lasting. And so his main thesis was there's only so much that even the best intentioned, most strategic litigation can do to get the spigots flowing again. Give me the counterpunch to that as a state attorney general who is making those spigots flow again.
I read the story, and I don't disagree, frankly, with the broader premise. I think two things can be true.
Okay.
On the one hand,
I'm a big fan of both and, so
we're lawyers, right? So on the one hand, we have generally been successful. And not only have we been successful in getting the type of outcomes we want, but the administration has broadly complied. The funding freeze, they have turned the funding back on. We had to go to court a couple times to enforce that order, but they ultimately did. And I'll give you a very specific example. We sued in a separate funding case on a couple of relatively smaller, $600 million, not chump change, but relatively smaller in the broader scheme of things, programs that fund teacher training programs, particularly for low-income kids, for rural communities, for math and science, for special needs. We had two universities in our state that were training teachers to be in the classroom next fall. We're at the time now where they're making decisions for our kids. I'm a parent of two kids. I have kids in the public schools. So, these are the time when decisions get made. I was at Montclair State last week. The administrator of one of those programs came up to me and said, "Thank you. Your lawsuit got the funding flowing, and now those teachers are going to be in Newark and Orange public school classrooms in the fall." The administration complied with the TRO there, and that's real relief to those residents and those kids. But we shouldn't minimize how unprecedented it is what this administration is doing. When you have the president of the United States, the vice president. Now, J.D. Vance and I are about the same age.
Yeah.
We went to law school at the same time. I think I paid attention. I'm not sure he did. Because when you question, even raise the specter that you're not going to adhere to court orders, once you get that toothpaste out of the tube, it's very hard to put it back in.
Well, that's actually a good question. I want to follow up on the teacher training suit because I want to talk about that in particular. But let's go back to putting the toothpaste in the tube, because you correctly noted that where the OMB funding freeze cases are concerned, there were some concerns that they weren't abiding by them. And you had to go back to a judge in Rhode Island in particular I'm thinking about, and basically say, they're flouting the order. Make them understand that your order means what it says. Yeah. There are folks here that think that was, in fact, the crossing of the Rubicon, that was a deliberate disobedience of a court order already. Would you go that far?
Well, we had to go to court a couple times to compel them to comply with it. So it's certainly not something I'm happy that it occurred. But the positive news in that case is they ultimately did comply. The funding has been turned on. And look, it's one thing as scary and unprecedented and dangerous as it is for the senior most officials in the United States, president, vice president, attorney general, senior people in the White House, questioning the legitimacy of courts. That is unprecedented. We should condemn it, and it should be bipartisan condemnation, frankly. But the fact that they were willing to listen, that attorneys in the Department of Justice had to look a judge in the eye and say, under their own integrity as an officer of the court, that they were going to adhere to this order. That's where I think, push came to shove, and ultimately the orders were listened to. But I don't want to minimize it. We are in a very dangerous and precarious place as a country.
Do you find, as somebody who's actually been to court and been to these hearings, one of the things that comes across to me in reading transcripts is that oftentimes the lawyers at the Department of Justice who are being sent in to defend these questionably lawful actions are people who are very far apart from what is actually happening on the ground with DOJ, in agencies, at the department itself at its most senior levels, and therefore they can't make representations to the court about what is actually happening because they are being kept so far apart from decision makers that they can't actually tell the court whether or not it's happening. And you can see judges, you can feel their frustration come across on the page. Can you or can you not answer this? And many times the department lawyer can't answer it because they've been walled off from the truth so that they don't have to lie in court. What is that like as their adversary to watch? And am I reading that right from the transcript?
Look, I think certainly when it comes to DOJ, I don't think anyone knows what Elon Musk is doing, including the President of the United States. And I think that's been clear because they've made public representations and representations in court about what he has been doing and his team of hackers, which is what they are, has been doing, and that have proven to be false. Like, for instance, originally they said, oh, they're not taking any data. And then they admitted in our case, oh, actually, we did take data, and it's now quarantined.
Just to be clear for our viewers, which case are we talking about?
Sorry, there's so many. This is the case we filed in New York where we're sitting against Doge for taking access to private data that is comprised in the Treasury payment system, basically the entire payment system.
This is the case before Judge Vargas we're talking about now?
Correct.
Yes.
Yeah. So
I want to go back to the teacher training grant lawsuit for a second, because it's not lost on me that the administration now has 3 pending Supreme Court applications in cases that they've litigated. One is challenging the sort of breadth of the birthright citizenship EOs. One has to do with the probationary employees restoration injunction from California, essentially saying that the judge was not within his rights to order that a slew of probationary employees at 6 particular agencies have to be restored. And the third is about the teacher training grants. And when I look at those cases, what they share in common is not their expensiveness, right? There are other cases that have cost this administration far more money. The OMB funding freeze case is one of them. The climate change case, where EPA grants were challenged in D.C., is another. As a result of the decision in that case by Judge Chutkan, 2 grantees got $16 billion of grants that have to go out the door to them. The teacher training grants case is dwarfed in volume by that, and yet the administration went to the Supreme Court, is seeking an emergency stay of the relief that allows that spigot to be turned back on. Why are they fighting that one? Why that?
Well, if I could get into their heads on a whole bunch of things, I think I'd have the answers to a lot of questions you might ask.
I'd be much higher paid if I could.
Yeah, exactly. I'd be a much more interesting guest. But look, and just to be clear, the probationary employees case that you referenced is actually not the state AG's case.
Right, there's another one in Maryland.
It's hard to keep track. I will say I don't know exactly why they're going up on all the cases. Take the birthright citizenship case. One of the things they're seeking in that case is to invalidate the national injunction of it, which has been an issue in the Supreme Court now for several years. They've expressed some concern about national injunctions, and I will
say certain justices have expressed concern about nationwide injunctions, and in the application that they're making in the birthright citizenship case, they are very careful to highlight those dissenting opinions from Alito and Gorsuch and Thomas, highlighting their objections to these nationwide injunctions, but it is not necessarily a universally shared objection, correct?
For sure. And I think the birthright citizenship case is a particularly bad vehicle to raise that objection, because the idea that your citizenship status, not only is it ridiculous that for the first time in 157 years, a child born on American soil would not be treated as a citizen generally, something that we settled with a civil war. There was only a 10-year period where that was even at issue in this nation's history. But it's even more absurd to say that somebody born in New Hampshire or Mississippi has a different citizenship status than somebody born in New Jersey simply because their state attorney general didn't join a suit, which is effectively their argument. And so I think that's why the Supreme Court said, okay, we know you think this is an emergency. Normally they'll give you a few days. Well, go ahead and take a few weeks or a month to respond.
Right. I mean, Justice Jackson there is basically saying to them, yeah, we'll hear it, but they have until April 4th. This application was filed March 13th. Just to put this in context for people watching who are not as familiar with appellate litigation as you and I are, when you got an emergency application to the Supreme Court, what? You got an emergency application to the Supreme Court and the justices say, hey, you got 3 weeks to answer it. That's not necessarily a great sign of how it's going to turn out for you. I'm not predicting necessarily how it will turn out. If it turns out the other way, I will eat my words. But when the justices don't tell you, I want a response in 2 days, as they have in the teacher training case, that's an interesting one. So let's talk about probationary employees for a second, because you mentioned that you are, as a state, a party to another case in Maryland. And one of the things I wanted to talk about with you is these sort of overlapping cases where states might be party to one and others have been brought by impact litigation groups or unions or people who represent, for example, immigrants. Is in the birthright citizenship context, one of those decisions comes from an immigration advocacy organization having brought those suits.
And we have immigrant plaintiffs alongside us in the Massachusetts case as well.
That's right. In the probationary employees context, one of the suits is brought by unions, and it only talks about 6 agencies. The other suit brought by states, talks about, I think, somewhere in the realm of 17 or 18 agencies, and there's some overlap. And there are now 2 injunctions, one of which allows probationary employees to be restored if they're put on administrative leave, whereas the California judge says, that's not restoration. Are these overlapping lawsuits that get at the same fundamental legal issue but seek slightly different relief? Is that frustrating to you, or is that a good thing in terms of sort of vindicating larger policy concerns?
Look, I think one thing you've seen as attorneys general, we've tried to be as coordinated as we can because typically speaking, with some shades of gray, a harm that affects New Jersey typically affects California or Massachusetts or Illinois or on, or New York. You know, I don't think we should take offense to the idea that individuals who have interests that are harmed are going to court to seek redress. That is the American legal system at work. What this administration, this president has expressed is another unprecedented thing, is hostility to the idea that people would even go to court and question them.
Right.
And so, no, it doesn't bother me. And I think, look, if the administration wasn't violating the law and wasn't hurting people, then, I mean, that's what standing as a legal argument is the law being broken and am I being hurt? Then people wouldn't be able to go to court and file suit. And so
I'm going to borrow that, by the way, the next time I have to describe standing on air. Is the law being broken and are people being hurt?
Yeah,
Okay.
that's effectively what we're talking about. And so, you know, for individuals or organizations who might have slightly different interests than states, sometimes it makes sense and it's totally appropriate for them to go to court because like the injury to a state might not develop sometimes immediately. It might take some time for it to become clear that states are going to be harmed. Sometimes it might be clear more quickly than the individual. So it does make sense that you see multiple cases. And frankly, given the scope of the harms we're talking, it's not like they're injuring a few people. Like Medicaid affects 75 million people. Birthright citizenship affects thousands of people in every state in the country every year. So these are significant harms that it doesn't surprise me that you're seeing a rush for litigation from various interests.
Well, can we go back to birthright citizenship for a second? Yeah. Not for the sake of birthright citizenship, but if the court were to enter an order curtailing those injunctions and saying that they're applicable only to the parties who came before the court, not even just in the jurisdictions that decided it, which would mean just those, 5 to 10 parties who brought a case in, let's say, Northern District of California, the District of Massachusetts, et cetera. Can you walk the people watching this through what the implications of a Supreme Court saying nationwide injunctions are no more, or at least signaling that and issuing a partial stay of the injunction? What is the impact of that on real people and their lives? And what is the impact of that on the larger litigation battle against unconstitutional or otherwise unlawful policies that this administration is pursuing?
Yeah, I think the birthright case is a perfect example to highlight the absurdity of what that would produce. I live in New Jersey. I think it's the greatest state in the country, but a lot of people pass through it. And so we live bordering New Jersey or New York. We border Pennsylvania. So let's say you live in South Jersey and your child is born at Children's Hospital of Philadelphia, which happens a lot. And your child is a birthright citizen if they were born in New Jersey. But if the court said, no, not for they won't issue a national injunction, well, Pennsylvania is not in that case. So parents live in New Jersey, but a child born at that hospital in Philadelphia who is going to, once released, come back to New Jersey, what that would mean is, that child's status, again, the order doesn't say what they are. It says they're not citizens. There's some secondary status of citizenship or residence that we've never had in this country. And for the state of New Jersey, well, we're responsible for educating that child. We're responsible for paying for health care for that child. We're responsible for providing all kinds of services for that child, which, if he's a citizen or she's a citizen, is supported in large part by the federal government. If they're not a citizen, in many cases, you don't get the same kind of support. So our case makes that clear. You can't have this secondary class of citizens that we don't know what they are because it hurts us. And for a family that's going to make a decision about, do I go to the right hospital for my child and maybe cross a border and give birth and then have to come back to my state? But yet now suddenly that child is not a citizen of the United States? I mean, it's absurd. I don't think anybody thinks that's the way the Constitution should work. And that's why I predict the Supreme Court will say no. But at the same time, you have the federal administration, the Department of Justice at the Supreme Court saying, no, that's exactly how the 14th Amendment of the Constitution is supposed to work.
Well, it's sort of a patchwork of state law and regulation, not unlike in the reproductive justice context, just now applied to the birth of children as opposed to people exercising their reproductive rights. I want to talk about a couple of other things, including one thing that hasn't materialized into litigation yet. There's been an executive order that has to do with the administration of elections and specifically about voters having to show proof of citizenship, but not through a birth certificate, which isn't one of the documents that the president says counts. You have to have a passport. About half of U.S. citizens have a passport at this time. That may even be overstating it. There are some objections that I've read already raised by certain attorneys general. One is that A, it could restrain the right of many lawful citizens, millions of them, to vote because they don't have the right documents. But two, that it's also an incursion on the rights of states and Congress to decide the time, place, and manner of elections, which is a constitutionally given right to them. What are your concerns about that, EO, as a state attorney general?
I mean, how much time do we have?
You got to ask your folks here.
That order is among the various orders they've issued, just so unbelievably and blatantly unconstitutional, and they know it. But like, think about what they're trying to do. They're trying to dictate to states their right to they want the federal government to dictate to states how to run their elections. The most fundamental right is the right to vote. They want to tell states how they can administer their elections. And if they don't, they'll defund our police. That's what the order says. They will yank all law enforcement funding as a stick to make you comply with unconstitutional directives about how to run your elections.
Without making promises about your particular state, you think it's fair to say that we'll see some litigation brought by more than one state government with respect to that order?
Oh, yeah. They're going to see us in court on that one for sure.
Okay, we got time for one more question, and this is about law firms. This is a big thing for me because I am a veteran of 15 years of two different big law firms that made significant pro bono investments while I was there, including in education and reproductive justice. I saw the letter that you and multiple other states' attorneys general signed, basically saying this particular directive to the attorney general to start investigating law firms that have been involved in litigation against the administration and to take corrective measures to ask states' attorneys general to work with the U.S. attorney general to punish law firms that pursue DEI policies is particularly offensive to you. There was some really tough talking language in that letter. One person I talked to yesterday said, look, that letter is a show of solidarity. Whether or not it has any legal impact is beside the point. The solidarity itself is the point. But is there something, or more than something, that states can do to ensure that law firms operate without the bullying thumb of the federal government on them?
I think as the judge in the case, Perkins Coie was the first law firm targeted by this administration for the work.
Second after Covington and Burling.
That's true. Sorry, excuse me. For the work done by a lawyer who doesn't even work there anymore, by the way. And as the judge in that case said, where we supported, and that's something I think we can talk about, state AGs can provide support for law firms that want to do the right thing and stand up to these unlawful, unconstitutional attacks.
What does that support look like?
Well, we filed an amicus brief. We showed solidarity. We will speak out publicly. I wish, frankly, we had 50 state AGs on that letter because this is not a partisan issue. As the judge in Washington said, that order sent chills down her spine, and chills down my spine. If people can't go to court to defend their rights because lawyers are too afraid for their livelihoods or their safety, because there's threats of prosecution that they've made, then we are no longer a democratic republic. We no longer live in a country that is governed by laws. When you attack judges for doing their job, threaten to impeach them, again, physically threaten them, when you tell lawyers that, oh, if you take a legally or a politically disfavored client, cause, issue, whatever it may be, you're going to get hammered. You're not going to be allowed in federal buildings. You're going to have your security clearances revoked. You're going to be threatened with...
Some of those people never had security clearances, I should note. Some of it's performative and some of it's practical, right?
And your clients that are unrelated to that matter are going to be punished in the same way. They're not going to get federal review of their cases. I don't know how we survive as a country if that is permissible. You want these businesses who are out here, these clients that are apparently running to law firms where they're not being threatened, I want to ask them, go to Russia and China and tell me what happens when your property rights go to court and how strong your protections are. We are a nation, the reason why we revere the rule of law, I know it can sound abstract, is so that the government can't wake up one day and decide that you or I aren't favored and show up and take our house and put our kids in different schools or do whatever it is they want to do without legal recourse.
All the liberty and freedom that purportedly those who are actually perpetuating these actions say that they stand for.
100%. And the courts are the place that we go, and lawyers are the people who go in on our behalf. There has never been a situation where we have said as a nation that we are going to hold you personally accountable for doing your job, for going to court and representing your client's interests, which as lawyers, and you know this, we all took an oath to do zealously. In fact, we can be held professionally liable if we do for not doing it. And so I really think, this is something that the public, I understand, is not going to fully grasp the significance, which is why they're doing it in this way. They know this is going to go over the heads of, or it's not going to catch fire on Elon's social media algorithms. But for everybody who knows better, we have to speak up. And I do think this should be bipartisan because, look, if this is the way it works now, is it okay then if a Democratic administration comes in and starts targeting, and I could name the firms that represent the interest groups that they care about? The answer for me is no. Of course it's not okay. But you start chipping away, like I said, the toothpaste comes out of the tube, you start chipping away at these norms, then the Constitution, as strong as it is and as important as it is, 2.5 centuries, is ultimately a statement of principles that we believe as a nation matter. And those principles are only as important as people in power saying we're going to follow them. And this administration has effectively thumbed its nose at it in the first 60 days and done things that even those of us who were concerned, I didn't think we'd be at this point 2 months in.
Well, we're 60 plus days in now. Will you promise me that we can have another conversation around the 100-day mark and we can see if the toothpaste is still in the tube?
Anytime.
Okay. Matt Platkin, thank you for coming.
Thanks for having me.